Good. There we go. Welcome today to our presentation this afternoon. Elder Abuse Prevention Ontario is so pleased to be collaborating with the Community Legal Education Ontario to host this webinar today on power of attorney for personal care, safeguard wishes to take steps to prevent abuse. And we are joined today with our presenter, Megan Stokely, who is the lawyer and advocate of North for Elders and Seniors. She's a lawyer there and also the lawyer for the Sudbury Community Legal Clinic. So we're pleased that you've also joined us here to take time out to learn a little bit more about this important topic. CLEO, which is the short form for the Community Legal Education Ontario, has done a series of webinars as well as Elder Abuse Prevention Ontario on powers of attorney for personal property, but now we thought we would expand some of the work that we are doing on our end around personal care. So if you have missed either one of our presentations, you can go to either one of our websites to look at past webinars on powers of attorney for personal care. So without further ado, I do want to get started and just talk a little bit about our land acknowledgement, and then we'll begin with some housekeeping. So we acknowledge that we gather on the traditional territory of a number of First Nations and acknowledge their stewardship throughout this land, throughout the ages. We seek a new relationship with the original peoples of this land, one that is based in honor and deep respect. If you haven't joined our webinars before, here's a few housekeeping items we'd just like to go through. Everyone will be muted during the presentation today. Our speakers will be visible. If we are co-presenters, we won't be online. You'll just see our ASL interpreters and the speaker visual. If you'd like to make your screen larger for the speakers, you can either pull the line of the speakers to the left of your screen or to make them a little bit larger, or you can change the view under the little grid at the top to choose which kind of mode you'd like to see the presentation in. Again, just to remind people that you can put your comments in the chat box as we go through. We're going to try to have an interactive presentation today, so you can put your comments there. If you have a specific question during the presentation, please put that in the question box today. It makes it a lot easier for us to make sure that we don't miss your question during the session. We will be asking at the end of the session to do an evaluation. We have a QR code, but we'll also be sending you a link as well. And your feedback is so important. And because we've had such overwhelming response for this presentation, feedback on future topics, maybe related to this issue or others, really helps us guide our future direction and providing education to meet your needs. And as I said, this is recorded and will be posted on both CLEO and EAPO's website in the next coming days. And lastly, we do respect your privacy and confidentiality in regards to the circumstances that you might be encountering related to power of attorney for personal care. If you have a personal situation, please reach out to either of our organizations and Megan, maybe offline, where we can get maybe more in depth around regarding your situation. We can answer personal or sort of general questions today and try our best to answer those. But again, you can reach out through our email and our websites to access further requests for information or a case situation that you might be encountering. Just a really quick overview of Elder Abuse Prevention Ontario. Our vision really is to make sure that seniors are free from abuse, have a strong voice, and feel respected. And we do this through, creating awareness, doing education sessions such as this, and working with our community partners to advocate and assist older adults in the community. We are responsible for implementing Ontario's strategy to combat elder abuse, and we are funded through the Ministry for Seniors and Accessibility. These are the three pillars of that strategy, which I just indicated around education, training of our frontline providers, and working with our community partners. I am going to ask Karen from CLEO to talk a little bit about her organization before we introduce our speaker.
Thanks so much, Ryan, and thanks to Elder Abuse Prevention Ontario and you in particular for inviting us for this collaboration. We had over 600 people registering, so obviously it's a very important topic. So as Ryan said, my name is Karen. I'm from CLEO, where I work as a legal education trainer. And I just want to very briefly describe CLEO's work on the next few slides. So we are one of Ontario's 73 legal clinics, but we're considered what they call a specialty clinic because we provide public legal education and information only. So we don't provide legal advice or we don't see clients. We produce information to help people understand the law and exercise their rights. And we do this by providing practical and easy to understand legal information. A very big part of our work is supporting frontline workers to assist people who come to you with questions that may involve the law. So your clients, your community, people you support in your work. And all of our information is in English and French, and we do have some resources in other languages. Can you go to the next slide, Ryan? Thank you. So we do have three main program areas, and this is our CLEO Connect page. And this is where, if you're a community worker, you will find a range of trainings and tools to support you in your work. This is where you'll find our Hot Legal Topics series. These are webinar trainings on a variety of legal topics that will support you in your work with clients and community. So I highly recommend you subscribe to get regular updates. And again, they are run in English and in French. This is our Steps to Justice site, and here is where you'll find a wealth of legal information in 17 areas of law, again, all written in accessible and plain language. So this site provides actions that can be taken, literally outlined step by step to address or avoid a legal issue. We offer the same on our French site, Justice Pas à Pas. Here you'll also find a live chat where we offer live support daily to help you find what you need on the site, but also to give you customized referrals around the province. And so there's a lot of really great tools here, like letter writing tools, flow charts, illustrations of courtrooms, checklists, and referrals to services across Ontario. And if you're on the Steps to Justice site, it will lead you to our interactive guided pathway tools. So these are tools that help you complete forms, court forms. You can create powers of attorney, wills. There is a new guided pathway on elder abuse and family violence. You will get a taste of the guided pathway today in our training. Megan is going to speak to the guided pathway, power of attorney for personal care. There's also one on property. So you will get my contact information after the webinar in the slides. So feel free to get in touch if you have any questions as I quickly go through all of this information. I'm now going to hand the floor back over to you, Ryan.
Great. Thank you, Megan. And yes, and I do also encourage people to check out that website, and we will talk about the guided pathways today. They're great resources. So it gives me pleasure to introduce our speaker today. So Megan is a staff lawyer, as I said, at the Sudbury Community Legal Clinic. She was called to the bar in 2017 and spent 4 years practicing criminal defense, appearing in the Ontario Court of Justice and the Superior Court of Justice, as well as the Court of Appeal. In 2022, she transitioned into elder and senior law and currently runs the Advocacy North for Elders and Seniors program, providing services to low-income seniors across Northern Ontario. So without further ado, I am going to allow Megan to begin the presentation by sharing her screen, and I will be going offline.
All right, good afternoon, everybody. So thank you to both Karen and Rand for organizing this today. Power of attorneys is such an important topic for everybody to be aware of, certainly because it does have that intersection between so many issues with elder abuse that come up, and then people's desire to plan for their future and make sure that their wishes are being respected. So because it's January, everybody is probably talking in their family and saying, it's time to get our affairs in order. Let's get the will done. Let's get the power of attorney done. So this is the perfect time to get into this topic. So today I'm going to focus on just the power of attorney for personal care. That is different from the power of attorney for property. They're going to have separate considerations. So if you're signing in and want to have property questions, we're not going to focus on that today, but some of the information can be shared between them. This information is important both if you're here to make a power of attorney, maybe for the first time, you've got questions about it, you want to know the basics, but also if you're a community worker and you're supporting someone who is being pressured into having a power of attorney or who wants to have more information on it. So this is useful no matter where you're coming from today. So I always like to start though with myth busting. So I'm going to give you a few questions. If you've got access to your computer in the chat room, feel free to throw in true or false into the chat. Otherwise, you can think it out loud and see how much you know about power of attorneys already. So the first myth is my power of attorney should include my future healthcare instructions. Is that true or is that false?
So Megan, it's Karen here. I'm just going to read them out. There's quite a mix of true and false, but I think, well, no, I think it's sort of 50-50 on this one.
And that's why I put it out there, because this is actually one of the most frequent questions I get asked. And so this is false. Your power of attorney document is chiefly designed for you to name the person who's going to make decisions for you. It's not the best place to put in what you actually want the decisions that are going to be made. If you wanted to do that, you're going to have a 200-page document covering everything from vaccines to surgeries to long-term care homes. So this is where you can name a person, and it's better for you to actually talk to the person and let them know what your wishes are going forward. So second one here, my common law spouse can make healthcare decisions for me without a power of attorney. Is that true or is that false?
I would say that most people are saying, well, again, it's sort of mixed, but I would say a lot of people are saying it's false.
False. All right. And this is actually true. So under the Health Care and Consent Act, your spouse or your common law spouse, and that's someone who you've been with for 1 year and you're living with them, they can actually make health care and treatment decisions for you without the power of attorney. Now, if you want someone else to make those decisions for you, such as your child or a friend that you're very close to, then you need to make a power of attorney and give them that privilege. We'll go into it a bit more, a little bit later in the presentation, but this is specific to those healthcare treatment decisions. They're not your personal care decisions. The third one here, a hospital or a long-term care home cannot require me to have a power of attorney. Is that true or is that false?
I would say most people are saying true.
True. And there we go. That is true. So nobody can force you to sign a power of attorney document. This is a highly personal document. It grants a lot of overarching power to an individual to make decisions. And so you should never be pressured into it. Often we see hospitals, long-term care homes, retirement homes saying you should have this, but they can't actually require it of you. Last one here. I need a lawyer to make my power of attorney. Is that true or is that false?
Wow. I would say most people are saying, got a few trues in there, but mostly people are saying false.
And that is correct. You do not need a lawyer. You don't need me to make this document for you. There are lots of ways to make them. We're going to go into one of those ways today, which is the Guided Pathways online program. It's a free program to make power of attorney documents. There's also multiple kits out there you can use. I always recommend speaking to a lawyer. get some legal advice before you sign them, and certainly retain a lawyer if you're interested in that. But these are meant to be accessible documents, and there are ways to make them without a lawyer. So now that we've covered the basics, I've got a sense of what everybody knows. Let's start with how can you make this document? So Guided Pathways is an online program. It's completely free, and I'm just going to show you the sign-in pages. A little bit later, we're going to actually put a demo link in the chat room, and so you can go in there and actually play around with the program. But for now, I just want to introduce you to it. So the Guided Pathways program, completely online, it'll allow you to, this is what it's going to look like. It's in partnership with CLEO. It's going to say Steps to Justice, and there's always a nice big button saying Make a Power of Attorney. You always have the option of whether or not you want to create an actual account. That's going to allow you to save your document, come back to it, work on it over time, or you can just continue as a guest, right? Make it in one go, print it up, and you're done. So you do not need to make an account in any way. Once you're into the program, this is what it's going to look like. You're going to have a number of pages. You have this individual in the middle who's going to be with you every step of the way. The program literally is to guide you on the path to making the power of attorney. They're going to give you information and then give you prompts. So who do you want your attorney to be? What kind of, how can they make decisions? And you can just click the buttons or put in the information. And at the end, it's going to give you the document. Important to note that if you do make an account, you can always save and exit in the top right. But if you are perhaps making this secretly, if maybe there's some conflict in your family or pressure to do the document in a certain way, and you don't want others to know you're doing it, there is a quick exit button in the top left corner. That's going to take you straight to Google. Do not pass go, don't collect $200. You get out of the page very quickly, and no one's going to know that you were looking into this information, which unfortunately is a common occurrence. So that's why that button is here. So that's how to make the document if you want to do it online. But what are some of the basics that you need to know? So let's make sure we've got the same definitions. Step one is your attorney. So your attorney is not a lawyer. They're not a professional in any way. That can be friend, family member, your neighbor. It is the person who you are giving this decision-making power to. The grantor is you, right? Or the grantor is the person that you're assisting who's going to actually sign the power of attorney document. And then the power of attorney is, just like I said, it's the physical document. It is not your person. I hear over and over again people saying, well, my power of attorney said this, and my power of attorney wants me to do that. They are not the power of attorney. They are just your attorney. And the reason we don't want to call them power of attorney is we want to take that word power out of the equation. At the end of the day, you are giving your attorney duty and authority. They have a duty to you to respect your wishes and act on your behalf, and they have the authority to make those decisions when the time comes. The healthcare practitioners will listen to them and take their decisions. So it's not about giving power to somebody, it's about giving responsibility to them, and then they have the authority to act on that. So very important to keep that in mind going forward. So what kind of decisions is this attorney going to make on your behalf? Well, there's two camps. One is healthcare decisions. So that's going to be your treatment and assistive services. If you're in the hospital, that's things like helping you use the washroom, making sure you're bathed. It's also going to be admission to a long-term care home. So we'll see a little bit later, but there is a hierarchy of people who can make these kinds of decisions for you if you do not have a power of attorney document. Just like I said, your spouse or your common law spouse can actually make these decisions for you without the document. The other side is personal care decisions. So this is more of your daily life decisions: nutrition, hygiene, clothing, shelter. So are you going to go into a retirement home? Are you going to be living at home or have home care services? And safety, right? Have you started wandering out of your home? Have you started leaving the stove on when you shouldn't be? Your power of attorney is allowing you to assign somebody who can make these personal care decisions for you when you're not able to do that anymore. Without the power of attorney, no one can make those decisions on your behalf. They can only do the treatment and the admission to the long-term care home decisions. So who can make a power of attorney document? Simply put, you've got to be over 16 years old, which does mean if you've got a 16 or a 17-year-old child, they could actually make a power of attorney for personal care document and pick their friends to make decisions for them if they're not capable. So they could pick you friends over parents. So it is 16, it's not 18 like it is for the power of attorney for property. You also have to have a level of mental capacity. So obviously if you're unconscious, you can't be signing documents, but there is a standard of things you need to be able to understand before you can sign this document. What that means is that you need to understand the person you're appointing genuinely cares about you. And second, that they might have to make decisions for you. And that's a key word, they might have to. Because even though you're signing this document, it might never actually take effect. You could stay mentally capable your entire life and no one's going to have to step in on your behalf. Or something could happen in your 30s, your 40s, and unfortunately someone's going to have to make decisions for you early on in life. So it's important to keep in mind these are not automatic documents. The person who assesses your mental capacity to sign the document is the person who's making the document. So if you're coming to a lawyer or you're coming to me, I'm going to be sitting there and assessing whether or not you understand, does this person care about you? And are they going to have to make decisions for you? So if I have a client who says, I'm picking my daughter, I've got a good relationship with my daughter, I know she cares about me, that shows me they have some mental capacity. If instead they're saying, I just met this guy on a bus, seemed really nice, I want to pick him, I'm going to have questions of whether or not this person has the mental capacity to understand the guy on the bus cares about them or not. But because you don't need a lawyer, if you're making the document, then you're assessing your own mental capacity. And that's where it gets tricky. And that's why these documents are actually so easily taken advantage of, because when people lack capacity, they don't always understand what they're signing. So that's why, again, I recommend speak to a lawyer or speak to somebody before you sign any documents. So that's the mental capacity to sign the document. But there's also mental capacity to make decisions, and that's a different test entirely. And arguably, this is the more important test, the one you need to be aware of. So everyone who is receiving treatment has to either consent or not consent to that treatment. And in order to consent, you have to have mental capacity. If you are over the age of 16, that is presumed. So again, you could have a 16-year-old child, they're presumed to have capacity to make their own treatment decisions. It is going to be determined by the person who is giving you the treatment. So if you're in hospital and it's a doctor saying, we want to have a surgery, do you consent to that or not? They are going to determine whether or not you have capacity to consent to that treatment. They have to have some sort of reasonable grounds or information to believe that you lack capacity. So simply refusing to talk to them or simply making bad choices sometimes, that doesn't mean you lack capacity. They have to have more to go on. So what is mental capacity? Well, simply it's your ability to understand relevant information and your ability to understand reasonable, foreseeable consequences of making a decision or not making a decision. So the example I always provide is vaccines, right? Does the person have an ability to understand what a vaccine is, right? What the needle does, what kind of medication is going to be in that vaccine? And then do they have the ability to understand the consequences of taking the vaccine or refusing the vaccine? At the end of the day, though, mental incapacity is not making poor choices or having a diagnosis. So just because somebody has made a decision that you wouldn't have made or that you disagree with does not mean they lack capacity. If they can show that they were able to reason through it, then they have that level of capacity. I have a lot of people who come to me and say, well, my mother has dementia, right? She can't talk to you. Dementia is not incapacity. It's going to be, does this person understand the information I'm giving them? Can they retain it long enough to do something with that information? And then can they understand what happens if they make a decision or don't? Very important, capacity is situational. So it's going to be task and issue specific. So going back to that example of vaccines, you might have a patient in hospital who just doesn't understand anything about vaccines. They don't even know what a needle is at that stage. They don't understand a needle is going to go into their arm. But if you bring pudding into their room, they're going to say, oh, I hate pudding. I never want to eat pudding ever again. So they still have capacity to make some decisions and understand things, but they might not in other areas. And usually as decisions get more complicated, that's where we see capacity fluctuating or starting to fail. Someone might be able to decide whether or not they want to live in a long-term care home, but not if they want a life-saving surgery. That could be very complicated. It's also time specific. So going back to someone with dementia, they might be able to make decisions in the morning when they've just woken up, they're fresh, they can understand. But by the end of the day, when they're more tired, they might not have that ability to understand anymore. So it's important for healthcare providers to understand, if I have somebody whose capacity is fluctuating, I want to talk to them when they are capable. I want them to make the decision before I call somebody else to make the decision for them. This is so important because the power of attorney for personal care only kicks in once the person is found incapable. So if a person is still able to make their own decisions, that power of attorney document doesn't mean anything. It doesn't help anybody. You can make your own decisions. It's only when the doctor or the service provider comes in and says, you can't decide this, you're not understanding, that then they turn to the power of attorney document and ask your attorney to make decisions. Because capacity is situational, because it fluctuates, that means you might not be able to make a decision one day, but the next day you can. So your attorney should not be taking over and acting for you. The moment they've used that document once, holding on to that document for the rest of your life. They should always be going to you and asking you, what do you think about this? What do you think about that? So that you're part of the conversation and you can make decisions when you have that capacity. Now, very quickly, if you don't have a power of attorney document and you're not sure if you want to make one, there are people who can make healthcare decisions for you. Again, those aren't the personal care decisions. We're just talking about healthcare decisions if you don't have the document. So the first people are going to be those who have the document, an attorney under a power of attorney, or somebody who's been appointed by the courts. If there isn't somebody with a piece of paper who says, I'm in charge of making decisions, then it's going to be your spouse and your partner, next your children and your parents, and it could be all of them making a decision together. One person doesn't get precedent over another person. And then your siblings, and then other relatives. If you're in a situation where you have no family, you haven't made a power of attorney, then it's going to be the public guardian and trustee's office who steps in and makes those decisions for you, again, just for healthcare. So there is a hierarchy. If you decide never to make a power of attorney document, there are still people who can step in and make decisions for you if you end up in a situation where you can't do it yourself. So that's our first half. I'm happy to take any questions if any have come up.
Thank you so much, Megan. Yes, we do have quite a few questions here. And some of the questions are related to information that Megan will cover in the second half. So we'll get to those in the second Q&A. So this is a straightforward but important question. How can we know if a person has a power of attorney?
Simply put, you need to actually see the physical document. So there is no registry online. With wills, you can actually submit your will to the court to hold on to until you pass away. That's not true with power of attorneys. So someone who's made a power of attorney should have it in a safe place in their house, but they should probably let their attorneys know it exists and where it's being stored so they can access it when they need it. So unless you've seen the document, you're not going to rely on somebody saying, well, I'm the attorney, you can just believe me. You need to see that document.
All right, great. So the second question is, what about a notary public in Ontario? Do they have the duty to assess capacity?
Generally speaking, if you're going to just a notary public, their role is just to make sure you understand what you're signing, and that you're swearing to it. So your power of attorney actually doesn't need to go to a notary public. You can have two witnesses witness that document, and it doesn't need to be a lawyer. They don't need to notarize it. So it's the person who's drafting the document or making the document is the one who's assessing your capacity to sign it.
All right, okay. Thank you, Megan. So this is a clarification. In Ontario, someone doesn't have to be 16 to make medical decisions. Is this true? I thought anyone was deemed capable regardless of age in Ontario.
So my understanding is that it's under the Health Care and Consent Act. It's presumed capacity over the age of 16. So you could actually be capable of making your own health care decisions if you're under 16. It's just not presumed. You've got to demonstrate you have that. Again, it's the ability to understand relevant information and the ability to understand the consequences of making a decision or not. So you could have a 5-year-old who is actually capable of making healthcare decisions if they can demonstrate that understanding.
All right, this is an interesting question. Can a power of attorney made outside of Ontario or Canada be used or enforced in Ontario?
So I've gotten this question before and I've looked into it a little bit. So everything I've discussed is under Ontario specific law. If you have a power of attorney that was made outside of Ontario, as long as it's compliant with Ontario law, then it can be relied upon and used. So it's got to have those two witnesses to the document, and it's got to be specifying the kinds of decisions someone's making. There is no set form for how that document needs to look under the Substitute Decisions Act. So it is possible it could be valid in Ontario, but you'd probably want to check with a lawyer first before taking that risk and relying on it.
All right, thank you, Megan. There's a lot of questions coming in. One question here is, what if there's a challenge from a common law partner towards the attorney? How does someone deal with that?
At the end of the day, if there is a valid power of attorney document that lists an attorney, they are the decision maker when you're incapable. So that person does have a duty to consult with family, to consult with your partners and take their input, but they get the final say. So unless there's an actual court challenge or some other application that's going forward, your attorney gets the final say in decision making.
All right, so I think we have time for a couple more questions. So this is, I don't know if you have any tips for this person, but I think this is a good question. Is like taking on a power of attorney a huge undertaking? If someone asks you, you want to make sure you can do a good job. What are some things to consider?
That's actually a great question. So, because most people, I'm sitting with the person who's making the document and asking them to assess, what do you think of your family member you're picking? Very rarely get to sit with the family members and ask them, are you comfortable taking on this role? So one thing to be aware of is if you are appointed as an attorney in a document, you always have the right to resign, right? And you can do that in writing and step down from the position. So if it does get too much for you, you don't have to stay in that position. It depends on the person you're dealing with, right? If you have somebody who's been in a car accident and is unconscious, you might only be assisting that person for a short period of time, versus if you have somebody who maybe has a diagnosis at a young age and is lost their capacity, maybe in their 40s or 50s, you could be in that role as decision maker for decades. So it's going to depend on the person. It's going to depend on why they lost capacity and whether they're going to get it back, and what kind of decisions need to be made. Some people just need to be given a good place to live and make sure they're being kept safe. Other people are going to have surgeries and huge decisions that need to be made. So just keep in mind you can step down if it does get too much for you.
All right, thank you so much, Megan. I think we'll let you continue on with your presentation, as many of the questions are related to part 2, and then we'll come back again in about 15 minutes or so with more questions for you.
Excellent. So because we've now covered who can make a power of attorney document and how you can make it, let's focus on who can be your attorney and how should you pick that kind of person. So I appreciated that last question because I'm going to ease right into that now. Your attorney is not a caregiver. They are a decision maker. And it's very important to keep that distinction clear in your mind. Your document is picking someone who is going to make decisions on your behalf. It's great if they also become a caregiver and they also provide that service to you, but that's not the role you're giving them. So keep that distinction clear in your mind as we go forward. So who can be an attorney for personal care? As long as they're over 16 years old, they can be appointed as your attorney in your document. It cannot be someone who is paid to provide you health care services unless they're your spouse, partner, or relative. So for example, if you're paying a PSW to provide health care services to you, if you have a nurse who visits you, they cannot be your attorney for personal care at all. So legally speaking, the standard for who can be an attorney is quite low. Somebody over 16 who you're not paying, but who should be your attorney is a different question. So the first thing has to be someone you feel comfortable talking to about your health. At the end of the day, this person might have to make a lot of healthcare decisions for you. You want to make sure you feel comfortable talking to them. So an example I get often is people who have multiple children. They might say, I've got 4 kids, but I only talk to one of them about my healthcare needs. One of them knows what kind of medication I'm on. One of them knows what I think about long-term care homes. So you want to pick somebody who you can have those tough conversations with, and not somebody who doesn't know anything about your health. They don't know about your history. You also want to pick someone you trust. This document is only activated when you're mentally incapable, meaning you might not understand what's happening or what kind of decisions are being made on your behalf. So you want to pick someone you trust absolutely to make decisions the way you want them made, not the way that they want them made. So if you pick somebody who's just going to be stubborn and only do what they want, that might not be the person to pick. Somebody nearby. This isn't an actual requirement, right? With today's technology, you could have an attorney who lives in BC or in Japan, and they can call into the hospital or they can call in wherever they need to and make those decisions over the phone. But if you do have somebody who's nearby, it is a nice benefit, right? They're able to access information about you more easily. They can be there in person. They can visit you. So it's a nice consideration to see, if you have, again, multiple children and some of them live far away and some nearby, you could list multiple attorneys, and it's nice to have one person who at least is close to you and can provide that assistance. Last, I want to caution everyone to be wary of PSWs, home care workers, and people you haven't known for a long time. And I don't say this to say that PSWs or home care workers are bad in any way. They are providing such a necessary role, and they provide great services. But they should not be the person you are assigning to be your attorney, right? They should not be your decision maker. One, if you're paying them, then they don't qualify anyway to be your attorney. But 2, this is also an area where we see quite a bit of elder abuse taking place, right? It can be an unregulated profession, and you could have someone who works in an organization, but you could also have somebody who just lives down the street from you and put up a poster and said, oh, I'll come clean your house for you. I'll do your dishes. You don't need to pay me. Don't worry. Why don't we go to the bank? So this is an area to be very careful about and be cautious if people are saying, do you have a power of attorney document? Have you thought about making one? Maybe we should go do that together. It's not a conversation to be having in that respect. So can you have more than one attorney? Absolutely. You can have as many attorneys as you'd like. There's no limitation on this whatsoever. So you could appoint one person to be your main attorney and then appoint someone else to be a substitute. So if your first person is unavailable or sick, or unfortunately if they've passed away, you have a backup person. You can also list multiple people to work together. So if you have, again, 4 children, or you've got 4 brothers and sisters, they could all be your attorney and make decisions together. You just want to consider, how are they going to make those decisions? Are they going to be able to get along, or do I need to have a mediator? If I've picked 3 people, can I have it set up that the majority wins in a decision-making argument, right? You don't want a situation where you've got 4 people and 2 are on one side and 2 are on the other one, and nobody's able to come to a decision. So if you're picking more than one attorney, just keep in mind, can they work together? Can they work together with my power of attorney for property, or the attorney for property? And are they going to be able to come to decisions? Now, can your attorney be compensated for helping you? So the simple answer to this is no. If you have made a power of attorney for property, then under the Substitute Decisions Act, that's the act that governs the creation of these documents, then your attorney may be compensated, so they can pay themselves for handling your finances. There's no similar provision for attorneys for personal care. So the easy answer is that the person who's making those healthcare decisions for you is not going to get paid for their work. And I've actually taken the section right out of the Substitute Decisions Act here, section 46 sub 3. So a person may not act as an attorney under a power of attorney for personal care unless the person is the grantor's spouse, partner, or relative, if they provide health care to the person for compensation, or they provide residential, social, training, support services for compensation. So what that means simply is your landlord, who you pay, cannot be your attorney for personal care unless they also happen to be your spouse or your partner or your relative. Probably wouldn't be your landlord in that case. And this is why I make the distinction that your attorney for personal care is a decision maker and not a healthcare provider. Because if they are providing you healthcare for compensation, and they're your spouse, okay, then they can be in that role, but it's different from being the decision maker. So this is not somebody who should be paid for making decisions. And if your attorney is saying, well, I've had to make a lot of decisions for you, I would like some money, you can always gift money to people, but they don't actually have a right to get paid for this role. So with all that said, let's return to the Guided Pathways program. In a second, you're going to see a link get dropped into the chat box, and feel free to click on that if you'd like. This is going to take you to a demo of the Guided Pathways program. So it's just going to be a few pages taken out of the program to give you a chance to click on it and play around with it. I'm going to have a copy of all the same slides on the PowerPoint here, so you by no means need to go with the link. You can stay with me. Just be aware, if you are relying on the ASL interpreter, they're going to stay on the Zoom call with me. So if you click on the link, you're not going to necessarily get the benefit of the ASL interpreter. So feel free, if you see the link getting dropped there, please feel free to click on it and go play around with the program. And let's look at the Guided Pathways. So my first slide here, duties of an attorney for personal care. So one of the great things about the Guided Pathways program is it doesn't just hand you the form and tell you to fill in the names of the people and then give it to you to sign. It's going to give you information as you go along. And this is probably one of the most important pieces of information you're going to get, is what is the actual duties of this person that you have assigned. And it's going to give you a whole list of them. And we're going to go through a few of them. So the first 3 there, you know, they have to act in good faith. You want somebody who's trustworthy and is going to make decisions the way you want them made. Keeping in mind, they're going to make healthcare decisions for you, as well as those personal care decisions. And a good attorney, so somebody who's doing their job to their fullest ability, is going to encourage your independence. So they are not going to come in and try to take over everything. And this is important because keeping in mind that concept that your capacity can fluctuate, that you could lack capacity in one area but not in others, it doesn't make sense for your attorney for personal care to say, well, you were found incapable one day, so I'm in charge of all of your decisions going forward. If they do that, they're overstepping. What they should be doing is including you in all of the conversations, letting you know any decisions that they're making on your behalf. And this goes so far as if you're in a coma, right? If you're in a coma in the hospital, your attorney should be talking to the doctors in the room with you, right? They should always just keep in mind that you are at the forefront and should be included in all the decisions, even though you might not actually be there. They are also going to help you participate, so in the decisions, and they're going to apply the least restrictive option when making a decision. So a common example, again, is somebody who has Alzheimer's and perhaps they are wandering out of the house and getting lost, right? A least restrictive option may be ensuring there's a gate around the house so they can still go outside and enjoy the property, right? But they can't wander into the street. It's not locking that person in their bedroom. So if the attorney is always applying the most restrictive plan, they're not necessarily acting in your best interest. They also need to consult your family and your supportive friends. So they shouldn't just be making decisions on their own in a room by themselves. They should be talking to your family, finding out, did you ever tell somebody about your hopes for a long-term care home? Have you ever talked to a family member about vaccines? It's difficult for one person to know all of your wishes in every area, so it's important for them to talk to your family. Your attorney will also not cut you off from your family members or your friends. If we go back to that scale I mentioned at the beginning, the healthcare decisions, which is treatment, admission to a long-term care home, and the personal care decisions, which is your nutrition, hygiene, safety, all of those areas. Not included on that list is visitation, right? Your attorney doesn't actually have power or the authority to decide who you can see and who you can't see unless it's safety, right? If a person is visiting you and they're hitting you or they're being violent towards you, that becomes a safety concern. But short of that, your attorney should not be cutting you off from friends and family in any way, and they don't have that ability. Now, if you're still using the demo, you'll see that we've listed a couple different attorneys. In our example, we've got Bruce, Gary Wayne, Selena Kyle, and Richard Grayson. So in the program, it's now told you all the duties that these people have to follow, and it gives you the option to decide, yes, I still want these people. I trust they're going to follow those duties, or no, now that I've thought about it, maybe I don't trust Selena Kyle anymore. Let's take her off the list. It's also going to give you an opportunity to decide how your attorney should make decisions. So they can either make them jointly, which means they all need to be in the room together or on the phone call together, and they have to agree on the decisions, or they can do it jointly and separately, meaning, let's say you have a child who lives in BC and a child who lives in Sudbury. One's close to you, one's far away from you. You can have one acting and making decisions if the other one is unavailable at that time. So they're not restricted, not forced to work together every single decision. So that concludes the demo. Feel free to come back into the Zoom presentation. We're nearing the end here. So the Guided Pathways program is now going to let you download an actual form, not in the demo, just if you actually fill out the information on the interview online. You're going to get 3 different documents. The first one is instructions for using a power of attorney for personal care. That's going to sum up a lot of what I've talked about today. And it's nice written instructions for you to read at night as you're trying to fall asleep. Really fascinating, but good for you to keep that in mind. And that's why it's so helpful to have it written down. It's also going to give you instructions for being an attorney. So you're going to give this to your attorney so they know you have duties, you have responsibilities. This is what you have to do. You don't just get this power, you have to follow some rules as well. And last, the actual power of attorney for personal care. So here I've got an example of what the form is going to look like. It's just a 3-page form. It's not too complicated, but you've got your revocation at the top. So it's going to revoke any prior power of attorney documents you have made. Important to keep in mind that test I mentioned at the beginning of whether or not you're capable of making a power of attorney document. So that's does the person have a genuine interest in your well-being? And are you aware that they're going to make decisions or might make decisions on your behalf? That's the same test for revoking a document. So if somebody has been misusing the document, making decisions in a way they shouldn't, if you can still pass that simple test, you can revoke the document. The document is also revoked anytime you make a new power of attorney document. So that's why that's the first line in this document. Next, you've got the actual person that you've appointed. Here we've got the Bruce, Gary Wayne, Selena Kyle, and Richard Grayson. So they're all working together, and then how they're going to make the decision. So they're working jointly and severally. So they don't all have to be in the same room together. The second page is generally just going to outline the duties and the authority that your attorney has. So they have authority under the Health Care and Consent Act to make decisions on your behalf. They have authority to make personal care decisions for you. If you've got the contact information for your attorney, the program will allow you to put that in as well so that you can make sure the healthcare provider knows how to call them. It's nice to have it in the document. Last is your witnesses. So like I said, you don't need a lawyer. You don't need to go to a notary public to have this document witnessed. It can be any two people, but the rule of thumb is it can't be your spouse, can't be the people you've named in the document as your attorney, and it can't be your children or the spouse of your attorney. So the program will tell you who can be a witness and who can't, but the point is you don't need to go to a lawyer to have this document witnessed. And this is just to show you what the instructions are going to look like. So the instructions on the left are for you to know what's in the document, and the instructions on the right are for your attorney, so they have that information they need. Last few slides here, storage and revisions. So just be aware your power of attorney document doesn't have a natural or an automatic expiry date. It's only going to expire if you revoke it or you destroy all of the copies. You should check it regularly to make sure your attorneys are still available, that they still want to do this role for you, you still trust them, you still communicate with them. So it's a good idea to just check on it every few months or every year to make sure it still reflects your wishes. And finally, storage. So important to keep it in a safe place. You don't want just anybody else to walk into your house and take the document, but it also needs to be accessible. Your attorneys can't act on your behalf if they don't have the physical original document. Don't give them copies. The copies aren't going to do anything. They need the original copy that you've made or a notarized copy of the document. So, and then keep track. Who have you given the document to? So have you given a copy to your doctor? Have you given a copy to your dentist? You know, does the retirement home have one? Because if you ever revoke it or sign a new one, you need to make sure each of those parties gets a new document so they're not relying on old information. So that concludes the presentation. Are there any other questions?
Hi, Megan, it's Karen here. So there are a lot of questions, and so I'm going to jump right in. All right, so some of this you have covered, but maybe you can clarify or take some time to add a little bit of additional information. There's quite a few questions about revoking the power of attorney. So one question here is if you found that, so people have clients where the power of attorney of one of their clients has found someone to deem them incapable, but the family members don't agree with this. Others that feel that the POA is grossly misusing funds. There's another question here, often around financial abuse reasons. And so how do you prove that, and how do you support someone to perhaps revoke their POA?
So very important to keep in mind that the capacity test for making and revoking a power of attorney is different for personal care than it is for property. So that test for personal care, I would say, is a very low test or standard to meet, right? Usually a person, you know, they might not be able to know about a surgery, but they can still determine if a person cares about them or doesn't. And so it's a much easier document for that person to revoke, even if they have doctors saying they're incapable of making certain decisions. And so important to keep in mind, just because someone is incapable of making healthcare decisions doesn't mean they're incapable of revoking that document. The same is true for property. Just because someone is incapable of managing their property doesn't mean they're incapable of revoking the document. But the test for making that document is different. It's a 7-part test. I won't go into all of it right now, but essentially it's, do they know what their finances are or how to get that information? Do they know what the duties of the attorney are? Do they know what kind of bills they have? So there's a little bit more awareness that needs to go into that before it can get revoked. But same thing, if someone is misusing their power as an attorney and the person is actually capable of revoking the document, it can be revoked or a new document can be made. And that's usually a good time to see a lawyer because the lawyer is going to do that test and meet with the person, and they're going to be a bit more careful about it than just, again, you don't want to just be handing a document to somebody and saying, sign this, because that's going to get a challenge.
Okay, great. Yeah, there's quite a few questions about that. So a couple of questions also. If someone doesn't have anyone that they assign as their attorney for personal care, but they want their wishes to be respected, if someone just writes up a document outlining their wishes, does this hold any power?
So technically, your attorney needs to follow your last known wishes, whether that's been given verbally or in writing. Now, if you don't have an attorney or you haven't made a power of attorney document, remember that pyramid I showed you, right? There's a hierarchy of people who are going to make decisions for you. The same principles apply, right? They need to be following what your last known wishes are. So if it is a blood relative, maybe a cousin or a nephew, right? That's who's left in the family. They've got to follow your last known wishes. So if you have completed a piece of paper and signed it with your wishes, it's going to really come down to, were they aware of that? Can they trust that document? How can they be sure that you're the one who signed it, when it was dated? It gets a lot more difficult. Certainly too, if the public guardian and trustee's office has to get involved, they're going to be asking around, they're going to be looking at information. Really, if they don't have information to rely on, they have to just act in your best interests. So as far as I'm aware, there is no official document you can sign in Ontario that says, here are my healthcare wishes, they must be followed. The only exceptions would be if you get a do not resuscitate form from your doctor and you have filled that out, or if you've applied for medical assistance in dying. Those are actual forms your doctor gives you that you fill out, but a handwritten form yourself isn't going to have necessary legal standing.
Okay, so we are coming up to time soon. There are so many questions that we will not be able to get to. So we may have to do some follow-up with you, Megan, just to cover some of these excellent questions. There are a couple about how can a person include their eligibility for the medical assistance in dying in a POA. I think you may have just touched on that. Did you want to just elaborate?
Yes, so the law surrounding medical assistance in dying right now has it that the person has to be capable when they apply for it. So what that means is that your attorney or whoever your substitute decision maker is can't actually apply on your behalf for that. So putting those instructions in your power of attorney document doesn't actually work or isn't going to make sense because they can't act on that. Your attorney can't make that decision for you. You still have to have a level of capacity to make that decision.
Okay. So we are coming up to 1 minute. So let me see here. So hopefully this is a quick one for you. What is the difference between lasting and enduring power of attorney? And that will unfortunately have to be our last question as we're 1 minute to 2 o'clock.
I don't believe those are legal terms. I think, so there is a power of attorney for personal care, which when you sign, it's effective when you're found incapable and will only be effective when you're found incapable. It doesn't expire. If you're considering a power of attorney for property, there is the power of attorney for property, and then there is a continuing power of attorney for property, which means it's going to continue into your incapacity. So it's a different thing. Lasting or I can't remember what the other term was, but you can put those in the documents. I don't think they're going to have a legal meaning, right? The document's only going to be effective when you're found incapable.
All right. Thank you so much, Megan, for being on the hot seat. We really appreciate it. I'm going to hand it over to Rayanne.
Thank you, Karen. Thank you, Megan, and for an excellent presentation and for everyone's participation and excellent questions. Maybe we should have made this a little bit longer, but we are thinking about doing maybe a part 2 because there's so many questions that have come up during the session. So thank you for that feedback. There are resources and supports I've been posting throughout the webinar, but just as for people to know that you can get a lot of this information on the CLEO website. So we will be posting this PowerPoint as a PDF, and we will be posting all the materials and links that you can access all these materials. So including powers of attorney for property care, as well as wills, which some people were asking about. And so in terms of other resources and legal supports, there are legal clinics where you can find across Ontario. I think, as Karen had mentioned, there's 17 different clinics. These are the links or the resources that you can find for the center that Megan works for, as well as the Advocacy Center for the Elderly is also an excellent resource, and can help people as well from their legal point of view. They do a lot of work in elder abuse and advocate for people when they're in situations of long-term care, community and retirement home, etc. The other arch is disability law, again, advocating for people with disability rights. And there is also the ProBo Ontario. Some people were asking in the chat box around what to do if there's issues around capacity. The Office for the Public Guardian Trustee is also another resource for individuals where the person's incapable and at risk. They can help to intervene based on their criteria. If it meets that eligibility and level of risk, they can help to intervene to support that person that's at risk. There's also the South Asian Legal Clinic that does also support individuals around some of these issues around family law. If you, just some other resources in terms of reaching out for support, there's a senior safety line that people can call 24 hours a day. They also have an online chat that people can access. And then I was posting some resources that we have on our website around our directory that we have of resources, information on frauds and scams, and we have a legal directory or legal resource that we did with ACE a while back. So there's many resources and information. And just to summarize, we do have a lot of exciting upcoming events in the next couple weeks. So if you haven't already registered, we do have a conference coming up that's free on risk assessment for older adults. So you can register. We will be putting that information in the chat box as well. And next week we have 2 webinars being held, one on looking at ageism and the other one looking at aging in place. So if you haven't already registered, you can find all the information on our website under upcoming resources or upcoming conferences to find that information. And again, for the providers to check out the CLEO Connect, as Karen mentioned, great resources, information, all the upcoming training that they have that's coming up. So please have a look at that, and hopefully you'll be able to attend some of those training sessions. And if you want to contact myself, there's my contact information, which is also on our website under staffing. We are very active on social media, all channels on a daily basis. So have a look and follow us. And retweet whatever you can do to help promote the work that we're doing in terms of prevention. Lastly, if you don't have time to, if you have time, if you take your camera, you can scan that and go right to finishing the quiz, the survey, 7 questions, very quick. And we will send out a link as well if you don't have time to do that today. And lastly, I had Karen's, I thought I had Karen's information. There's Karen's information there as well at CLEO if you want to contact Karen for further information about the information, legal information that they offer. So again, thank you to our ASL interpreters. We greatly appreciate, we know there's lots of, we go talk too fast sometimes, but we do appreciate your assistance in covering this and providing accessibility of this information to our broader community. So thank you again for participating, and we look forward to you coming to our conference and upcoming webinars and to the CLEO events. Thank you.